prepare or cause to be prepared a statement of account in respect of the actions and transactions of the liquidator and send a copy of the statement of account to all members if so required by the liquidation plan.
Mhm. A transfer.
A transfer including a prior transfer described in section 24, section 3 of all or substantially all of the assets of a company incorporated under this ordinance for the benefit of the creditors and members of the company is sufficient to satisfy the requirements of subsection 1, C, and D.
Okay. So subsections 1C and D says that the principal duties of a voluntary liquidator are C, to pay or provide for the payment of or discharge all claims, debts, liabilities, and obligations of the company. D, distribute the surplus assets of the company to the members in accordance with the articles. So under subsection 2, it says a transfer, including a prior transfer described in section 24.3 of all or substantially all of the assets of the company incorporated under this ordinance for the benefit of the creditors and members of the company is sufficient to satisfy the requirements for sections 1C and D. So what that means is that prior to the liquidation, they would have transferred the assets of the company and they would have formed a trust for the benefit of the company, the creditors, and the members, or any other person who would have an interest in the company. So that's what that section is saying. Because, you know, in terms of a voluntary liquidation, the liquidator would go out and assess who are the creditors, how much are they owed, and how they're going to pay them from the assets, how they're going to liquidate it. But what this is saying is that the ordinance also allows the liquidator, he can pay and discharge all of his debts and whatever is left, he can actually put it in a trust and then determine if there's any other funds owing to. So that could be done prior to the liquidation process. So in the Bahamas, what are the duties of the liquidator? No volunteers? In section 205 of the Act, let me turn to that page. It says the duties and functions of an official liquidator include collecting, realizing, and distributing assets of the company to its creditors, and if there is a surplus, to the persons entitled to the assets, investigating and reporting to the company's creditors and contributories upon the affairs of the company and the manner in which it has been wound up. The liquidator shall, subject to this act and the rules, use his own discretion in undertaking his duties, and the liquidator also has other duties imposed by the act and the rules, and such other duties as may be imposed by the court. The official liquidator has the powers necessary to carry out the duties and functions of a liquidator under this act, and may, with the sanction of the court, exercise any of the powers specified in Part 1 of the fourth schedule. So what does Part 1 of the fourth schedule state? What powers it is that he has? So the fourth schedule says, well, we didn't get to the powers yet, so let me hold on for the powers. So we'll come back. So that's the duties under the Bahamas Companies Act in section 205, subsection 1 and 2 and 3. So in TCI, it speaks in section 249 of the powers of the liquidator. And according to the act, it says all the powers of the company the liquidator has, except those that have been reserved to the members. So his powers are, but not limited to take custody of the assets, to sell any assets of the company at public auction or by private sale without notice. He could collect the debts and assets due or belonging to the company. He could borrow money from any person for any purpose that will facilitate the winding up and dissolution of the company. And he could pledge or mortgage any property of the company as security for any such borrowings. He could negotiate, compromise, and settle any claim, debt, liability, or obligation of the company. He could prosecute and defend in the name of the company or in the name of the liquidator or otherwise any action or other legal proceedings. He could retain solicitors, accountants, and other advisors, and he could appoint agents. He could carry on the business of the company if the liquidator has received authorization to do so in the liquidation plan and from the directors under section 2433A, as the liquidator may determine to be necessary to be in the best interest of the creditors or members of the company. And section 2433A speaks to not more than 2 years. He can execute any contract, agreement, or other instrument in the name of the company or in the name of the liquidator. And he can make any distribution in money or in other property or partly in each, and if in other property, to allot the property or an undivided interest therein in equal or unequal proportions. So if we go to the Bahamas, under the 4th schedule, it speaks to the powers of liquidators. And it says they have the power to bring or defend any action or other legal proceedings in the name and on behalf of the company. They can carry on the business as far as is necessary for its beneficial winding up. They have the power to dispose of any property of the company to a person who is or was related to the company. They have the power to pay any class of creditors in full. They have the power to make any compromise or arrangement with creditors or persons claiming to be creditors or having or alleging themselves to have any claims. They have the power to compromise on such terms as may be agreed all debts and liabilities capable of resulting in debts and all claims subsisting or supposed to subsist between the company and a contributory or alleged contributory or other debtor or person apprehending liability to the company. They have the power to deal with all questions in any way relating to or affecting the assets or the winding up of the company. They have the power to sell any of the company's property by public auction or private contract, with the power to transfer the whole of it to any person or to sell the same in parcels. They have the power to raise or borrow money and grant securities thereof over the property of the company. And they have the power to disclaim onerous property. So they also have powers that are exercisable without sanctions. So they have the power to take possession and collect and get in the property of the company. And for that purpose, to take all proceedings as considered necessary. They have the power. Go ahead.
Sorry, Ms. Archer, where are you reading from?
This is from the Bahamas Companies Act.
What section?
This is the 4th schedule.
Where is it, please?
The back, in the back.
Oh, in the box.
The schedules are in the back. So after you finish the legislation, then it gives you the table, which is a model articles of association.
Mhm.
And then that you would see the fees. After that, you're gonna see something says fourth schedule.
I see it now.
Okay. So under TCI legislation, they actually state the duties and the powers of the liquidator in sections 248 and 249 in the main legislation. In the Bahamas, they have it as a schedule.
Okay.
So they have the powers that the powers are differentiated between powers exercisable with sanction and those that are exercisable without sanction. So they have the power to engage staff to assist him in the performance of his functions. They have the power to convene meetings of creditors and contributories. They have the power to promote a scheme of arrangement pursuant to section 158. They have the power to draw, accept, make, and endorse any bills of exchange or promissory note in the name and on behalf of the company. They have the power to prove, rank, and claim in the bankruptcy, insolvency, or sequestration of any contributory for any balance against the estate. And they have the power to engage counsel, an attorney, and any professional qualified person to assist them in the performance of their function. And then it has a catch-all phrase and says it has the power to do all other things incidental to the exercise of their powers. So section 251 speaks to completion of liquidation. It says a voluntary liquidator shall file a statement that the liquidation has been completed. Once it's received by the registrar strikes the company off, issues a certificate of dissolution, and that's effective from the date of the issue of the certificate, and then is published in the Gazette, a notice that the company has been struck off the register and dissolved. So what does the Bahamas legislation say upon the completion of the liquidation? Nothing on the completion of the liquidation?
I'm looking.
You see how TCI's legislation is very, it's simple,
It's simple, it's not complicated.
no. And any question, anything that's connected to that section, they just refer you to the section, you can go there and it's very easy to read. So it tells you what happens on the completion of a liquidation and what you need to file. Found it yet?
No,
Still looking?
yes, ma'am.
I'm turning my pages to the section. So I can help you out. See if it speaks to it directly. No, not that. Didn't come to that section yet. Okay, section 271. 271 speaks to, they put it all together. Removal of the companies from register. And one is A, that the company is dissolved.
So you want me to read it?
That's it, because that falls in another section.
Okay.
They have it all together. Versus TCI tells you on the completion what you need to do. A little bit more. Because what it does in the Bahamas in section 218, it tells you what to do when you commence. So section 218 says that within 28 days of the commencement of a voluntary winding up, the liquidator or the directors in their absence shall file the notice of the winding up with the registrar, file the liquidator's consent to act, file the director's declaration of solvency with the registrar. In the case of a company carrying on a regulated business, serve notice of the winding up upon the relevant regulator and publish notice of the winding up of the Gazette. A director or liquidator who fails to comply will be liable to a civil penalty. And then there's the final meeting of the prior to the dissolution. And it says in section 222, as soon as the company's affairs are fully wound up, the liquidator shall make a report, an account of the winding up showing it has been conducted and how the company's property has been disposed of. And thereupon shall call a general meeting of the company for the purpose of laying before it the account and giving an explanation for it. At least 21 days before the meeting, the liquidator shall send a notice specifying the time, place, and object of the meeting to each contributory in any manner authorized by the company's articles and published in the Gazette. The liquidator shall, no later than 7 days after the meeting, make a return to the registrar in the prescribed form, specifying the date upon which the meeting was held, if a quorum was present, the particulars of the resolution, if any, passed at the meeting. A liquidator who fails to call a general meeting as required or fails to make a return is liable to a civil penalty. So that's as close as you could get in terms of completion of the liquidation, what the liquidator should do. So where a company is insolvent under TCI, section 252, it says a voluntary liquidator of a company in voluntary liquidation, who in the opinion of the company is insolvent, shall immediately send a written notice to the official assignee. And here it is now, the voluntary liquidator who contravenes this subsection 1 of section 252 commits an offense and is liable to a fine of $50,000. You notice their fines are much larger than ours. And once he sends that notice, he has to call a meeting of the creditors. And if he doesn't call a meeting of the creditors, he then is liable to another fine of $25,000. And then from there, he follows the insolvency ordinance in carrying out his role as the liquidator. So now the last section speaks about striking off. So how is striking off done in the Bahamas? How do you strike off a company? And how do you strike off a company in TCI?
So, 256,
Mm-hmm.
the registrar may strike a company off the register of companies if A, the company does not have a registered agent. 2, fails to file any return notice or document required to be filed under this ordinance or the regulation. B, the registrar is satisfied that the company has ceased to carry on business or the company is carrying on business for which a license, permit, or authority is required under the laws of the islands without having such license, permit, or authority, or the company fails to comply with the obligations under section 157 or the regulations to provide beneficial ownership information to the commission. The company fails to pay its annual fee or any late payment penalty by due date, or the company, being a regulated company, has its license canceled or revoked by the commission. Company, being a nonprofit company, carries on any activities that are inconsistent with the purposes stated in this article or the purposes specified in section 8, section 1, subsection 1. If the registrar is of the opinion that the company is trading or has the property, or that there is some other reason why the company should not be struck off the register or companies, the registrar may, instead of striking the company from the register, refer the company to the commission for investigation. Before striking a company off the register of companies on the grounds specified in subsection 1A or 1B, the registrar shall send the company a notice stating that unless the company shows cause to the contrary, it will be struck from the register of companies on a date specified in the notice, which shall be no less than 30 days after the date of the notice, and publish a notice of intention to strike the company off the register of companies in the Gazette. After the expiration of the time specified in the notice, unless the company has shown cause to the contrary, the registrar may strike the company off the register of companies. The registrar shall publish a notice of the striking of a company from the register of companies in the Gazette and may publish it in such other way as he considers appropriate. The striking of a company off the register of companies in effective from the date of the notice published in the Gazette. The striking off of a company shall not be affected by any failure on the part of the registrar to serve a notice on the registered agent or to publish a notice in the Gazette under subsection 3.
So when you look at the TCI legislation, in summary, when does the registrar strike off a company? One, as we know, is if it doesn't have a registered agent. 2, is when it failed to file returns. And it's the same thing in the Bahamas Companies Act under section 271. It says the registrar could remove a company that fails to submit any return notices, document, or it doesn't pay its fees. Or it can do so if it is amalgamated or merged, or like I said earlier, it is dissolved, or it refuses to comply with any directions given by the registrar, or if the company's registration is canceled or revoked, or the company has just ceased to do business. So it's similar to what's in the TCI, because like I say, it says you don't have a registered agent, you fail to file your notices and return. If the registrar is satisfied that you have ceased to carry on business, that you're carrying on business, but you don't have the license to do so. You fail to comply with the obligations for beneficial ownership. You fail to pay your fees, similar to ours. The license has been canceled by the commission, like in the Bahamas, the regulator. And then it has the company being a nonprofit company, carries on activities that are inconsistent with its purposes. And it says that before the registrar strikes it off, it sends a notice advising the company that it's going to be struck off and the date. And then it publishes its intention in the papers. So in the Companies Act of the Bahamas, section 271, again, subsection 2, it states that if the registrar is of the opinion that the company is in default, that means it hasn't submitted its returns, notices, and documents. It refuses to follow the directions of the registrar. The registration is revoked or canceled, or the registrar has reasons to believe that the company has ceased to carry on the business. The registrar, just like the TCI's legislation, will send a notice in accordance with subsection 4 to the company advising of the registrar's findings, and they will stipulate which one of the findings that they're striking off under, and they give them 21 days notice that the company will be removed from the register. And after that period, unless the company shows cause why they shouldn't be removed, the registrar removes them and is published in the Gazette, similar to what TCI does. A notice underneath this section is delivered to the company's registered office, its physical premises, or in the default, the notice published in the paper is sufficient. The notice, after the expiration of 90 days from the coming into force of the section, the registrar shall, without serving any prior notice, remove a company from the register which is no more than 20 years in default under subsection 2, and should publish the notice of the removal of the Gazette. So how long does a company have to be? How old should a company be before the registrar removes a company from the register in TCI? In the Bahamas, it says no more than 20 years. What's your time period?
The 90 days? No?
We're using 90 days. What section?
I must be looking at this appeal thing. I don't think that's it. At the bottom. Any person is aggrieved by striking off a company of the register of companies under section 256, made within 90 days of the date of the notice. Oh, no.
See, anything?
I'm looking. Years, but hold on, I wanted to say. What did they?
Yeah.
I don't know, it's 259, dissolution of company struck of the register of companies. Where a company that has been struck of the register of companies under section 256 remains struck off continuously for a
10
period
years.
of 10 years.
Ours is 20.
Okay, oh, so y'all is more.
Yeah, much more. 20 years is a lot. 20 years is a lot. So under our laws, under section 271, part A, it speaks to removal of companies that are non-compliant. So it says the registrar shall remove a company from the register of companies after being duly notified by the authority established under section 2 of the Commercial Entities Substance Requirements, CESRA, that the company is not compliant with the act, or where the company is not compliant with the register of beneficial ownership. So I noticed that you all have in the TCI, it speaks to beneficial ownership, but it doesn't speak to Commercial Entities Substance Act. Do you know why?
No,
I need to find out why you don't have that section. You've heard about it? That legislation
no, to be honest, no.
called CESRA. Maybe they didn't think you all needed it. What that legislation does is it looks at companies that are incorporated, and it sees whether or not they have a substantial standing in your country and whether or not they are liable for taxation. And then you have to report them to the jurisdiction. So before removing a company from the register, the registrar shall send a notice to the company advising of its finding, stating that unless the default is remedied within 21 days after receipt of the notice, stating that unless the beneficial owners of the companies are identified and verified within 21 days, the company shall be removed from the register. So where registered office certifies to the registrar that it is unable to identify or verify the beneficial owners of a company in accordance with Section 8 of the Register of Beneficial Owners Act, the office may resign as the registered office, and thereupon the registrar will remove them from the list. Now, I don't think your legislation goes that far. No, it doesn't. But it gives the company the right to appeal. So under Section 272 in the Bahamas Companies Act, it says that where a company is removed from the register of companies, the liability of the company and every director and officer continues and can be enforced as if the company had not been removed from the register. Now, you know, we also have the IBC Act. And the IBC Act has its own requirements for striking off. So under the IBC Act, Section 165, it states that the registrar, where they have reasonable cause to believe that a company no longer meets the requirements under the Act, they can strike off. And what the registrar is, after notifying by the authority established under, again, the Commercial Entities Act, that a company is non-compliant, they can serve an order for compliance. If they don't receive a reply within 90 days following the date of service, the registrar could strike the name of the company off the register unless the company or some other person satisfy the registrar that the name of the company should not be struck off, and publish a notice of the striking off in the Gazette. And where the company has otherwise complied with the requirements of the act, the registrar shall, upon request by the company, issue a declaration of compliance as prescribed in the second schedule. If the company fails to pay the increased license fees, the registrar shall, within 30 days following the date, publish in the Gazette and serve on the company a notice stating that the amount of the fees and the name of the company will be struck off if they don't pay the increased fees on or before the 31st of December the next year. A company that has been struck off the register under this section remains liable for all debts, liabilities, claims, obligations. And the striking off doesn't affect the liability of any members, directors, and officers. So it's the same as section 271A, subsection 4. So what's the effect of striking off in TCI? In TCI, section 258, it says,
58.
go ahead, 258,
Where a company has been struck off the register of companies, the company and the directors, members, and any liquidator or receiver thereof may not commence legal proceedings, carry on any business, or in any way deal with the assets of the companies, defend any legal proceedings, make any claim or claim any right for, or in the name of the company, or act in a way with respect to the affairs of the company, notwithstanding subsection 1, where a company has been struck off the register of company, the company or a director, member, liquidator, or receiver thereof may make application for restoration of the company to the registrar of companies, continue to defend proceedings that were commenced against the company prior to date of the striking off, and continue to carry on legal proceedings that were instituted on behalf of the company prior to the date of striking off. The fact that a company is struck off the register of companies does not prevent the company from incurring liabilities or any creditors from making a claim against the company and pursuing the claim through a judgment or execution, and does not affect the liability of any office members, directors, officers, or agents. In this section, and section 260, liquidator means a voluntary liquidator and an insolvency ordinance liquidator.
Okay, and so if you have a dissolution of a company struck off, section 259, what it says? After 10 years,
Yeah, after 10 years. After where a company that has been struck off the register of companies under section 256 remains struck off continuously for a period of 10 years. It is dissolved with effect from the last day of that period.
right? So it tells you that automatically the registrar then considers it to be dissolved. Under section 256, and 256 speaks to striking a company off, remember, for the different reasons. Either the company doesn't have a registered agent, it failed to file any returns, or the registrar is satisfied that it has ceased to carry on business, or it's carry on business without the proper authority, or it fails to comply under register of beneficial ownership, or it failed to pay its fees, or it has revoked or has its license revoked or canceled by the commission, or the company is a nonprofit and is not carrying on its business in accordance with its purpose. So those are the reasons that they're referring to. So then it speaks in 260 to restoration of a company. So when can a company be restored if it has been struck off? under TCI. And then we'll go to under the Bahamas.
Restoration of company who register of companies by registrar. Where a company has been struck off the register or companies but not dissolved, the registrar may, upon receipt of an application and upon payment of the restoration fee and all outstanding fees and penalties, restore the company to the register and issue a certificate of restoration to the register. Where a company has been struck off the register of companies ordinance under section 256, subsection 1A(I), the register shall not restore the company to the register unless he is satisfied that a licensed person has agreed to act as registered agent of the company, and it would be fair and reasonable for the company to be restored to the register. An application to restore a company to the register of companies under subsection 1 may be made by the company or a creditor member or liquidator of the company and shall be made within 10 years of the date of the notice published in the Gazette under section 256, subsection 5. The
Mhm.
company or a creditor, a member or a liquidator thereof may within 90 days appeal to the court for a refusal of the registrar to restore the company to the register of companies. And if the court is satisfied that it would be just for the company to be restored to the register of companies, the court may direct the registrar to do so upon such terms and conditions as it may consider appropriate. Notice of an appeal to the judge in chambers under subsection 4 shall be served on the registrar, who shall be entitled to appear and be heard at the hearing of the appeal. Where the registrar restores a company to the register of companies under subsection 1 or in accordance with a direction of the court under subsection 4, the registrar shall issue a certificate of restoration to the register of companies. Where a company is restored to the register of companies under this section, the company is deemed never to have struck off the register of companies. Where the company to which subsection 2 applies is restored to the register of companies, it shall immediately appoint a registered agent under section 45.
Okay, so that was the dissolution of a company struck off the register. So when you go to 261, it speaks to making an application to restore dissolved company to the registrar. And it said the application to restore a dissolved company has to be done to the court. And it can be done by a creditor, a former director, a former member, or former liquidator of the company, or any person who has an interest in having the company restored. And the application may not be made after the end of a period of 10 years from the date of the company was dissolved. A notice has to be served on the registrar, the permanent secretary of finance, the commission, or if at any time prior to this dissolution, the company was a regulated person. And each of whom is entitled to appear to be heard on the hearing of the application. So it says if the company is dissolved following the completion or the termination of a liquidation, the court will not restore the company to the register. That's section 262 TCI. The court may make it an order for a liquidator to be appointed. So it says in subsection 4, where the court makes an order restoring a company to which subsection 2 applies, and subsection 2 says where the company was dissolved following the completion or termination of a voluntary liquidation under the ordinance or under the insolvency ordinance, the court shall not restore the company to the register unless the applicant nominates a person to be liquidator of the company if it is restored to the register of companies, that the person nominated as liquidator consents to act and that that person is eligible to act as liquidator, and they must have satisfactory provision has been made or will be made for the expenses and remuneration of the person to be appointed as the liquidator. So where the court makes an order restoring a company based on any one of those three factors, it shall appoint as liquidator of the company the person that is nominated or some other person who is eligible to be the liquidator of the company. So what's the effect of restoration in TCI? In section 263, it says that where the court makes an order to restore a company to the register, a sealed copy of the order shall be filed with the registrar. In the case of a company to which section 2612 applies, that means a company where the registrar had said that it would not restore it because it was dissolved, and then it would actually look at three conditions: that the applicant nominates a person, that the person nominated consents to be the liquidator, and that the provision has been made to pay for that person. So it says, in the case of a company to which section 2612 applies, by the person appointed to be liquidator or the company under section 2624, and that's where the court makes an order to restore a company, and it appoints a liquidator. And in any other case, by the applicant for the order, on receiving a filed copy of a sealed order under subsection 1, the registrar shall restore the company to the register of companies with effect from the date and time that the copy of the sealed order was filed, and issue a certificate of restoration to the company register of companies. If the company was dissolved following the commission or termination of the voluntary liquidation, the company is restored as a company in liquidation under the ordinance or under the insolvency ordinance, and the person appointed by the court as liquidator is constituted liquidator of the company from the time that the company is restored to the register. A company is restored to the register of companies with the name that it had immediately before it was dissolved. If the name has been reused in accordance with regulations 41, the company is restored to the register with the company number name. A company that is restored to the register of companies is deemed to have continued in existence as if it had not been resolved or struck off the register of companies. So under the Bahamas legislation and the Companies Act, it says under section 273B, if the name of a company has been removed from the register under section 271, the company or creditor or member or liquidator may within 20 years immediately following the date of the removal apply to the registrar to have the name of the company restored to the register. The registrar shall cause the name of the company to be restored to the register if satisfied that the company at the time of the removal from the register was not in default or carrying on business and has paid the prescribed fee and filed the requisite documents and issue a certificate of restoration in the approval form. Now, section 273C says, after the 20 years, referred to in section 273 subsection 1, a company, a creditor, a member, or liquidator can apply to the court to have the name of the company restored to the register. And when an application is made, the court shall order the name of the company to be restored to the register if the court is satisfied that it would be fair and reasonable to do so, and the company pays all outstanding fees. Where the company is restored to the register, the company shall be deemed to have continued in existence as if its name had not been removed from the register. And where a company is restored to the register, the trust referred to in section 273, subsection 2, shall be extinguished and the property vested in the treasurer and revert to the company. Now, section 273, subsection 2 speaks to property company that's removed from the registry bona vacancia. So it says where company is removed from the register of company, all property and rights whatsoever vested or held on trust for the company immediately before its removal from the register, subject to and without prejudice to any order by the registrar under section 273B2 shall, prior to the expiration of the period of 20 years, be held on trust by the treasurer for members of the company for the duration of the 20 years. And after expiration of the 20-year period, be deemed to be bona vacancia and shall belong to the treasurer for the benefit of the Bahamas. I don't recall TCI legislation speaking to what happens after the 10 years. Let me see. Oh yeah, section 265 and TCI legislation. Any property of a company that has not been disposed of at the date of the company's dissolution, it vests with the Crown. So section 273D in the Bahamas says, where a company is restored to the register, the company shall be deemed to have continued existence as if its name had not been removed from the register. And subsection 2 shall apply to property which had vested in the treasurer at the time of the coming into force of the section, as well as to property vesting in the treasurer after the coming into force of this subsection. So notwithstanding anything to the contrary in this act or any other act, the Minister of Finance may in his direction or application made to him by or on behalf of the company which has been restored, by on behalf of person interested in the property of the company which has been removed from the register, he could direct the treasurer, subject to the terms and conditions from the Minister of Finance, whatever the minister sees fit, that any property that was vested in the treasurer and it has not been disposed of be reinvested in the company. So in the case of a company, such restoration and reinvesting of property shall be as if the company has never been removed from the register. And that's the same under TCI legislation. And the provisions of this section shall apply to property which had vested in the treasurer at the time in the coming of the force of the section of the act, as well as those that came after. And that's it for liquidation. That was a lot, right?
Yeah, that's a lot.
That's a lot. It's a lot. It is a lot, but at least you've gone through the legislation and now you can take your time and go through it. And like I said, yours is a little easier to follow than the Bahamas legislation. Now, those in the Bahamas, I think even though the IBC Act just have the 3 sections, striking off, restoration to the register, the dissolution, the effect of striking off, appointment of an official liquidator, the dissolution of company strike off. That part is like relatively simple because don't forget they made it easy because of the flexibility of the IBC. But if you incorporate a company under the CAC, All that we read today is the process that you have to follow and the considerations that have to be made. So it's not as simple as an IBC at all. So now let's turn to the final exam. Let's see. I thought of you all. And I
Hold on, let
said,
me get my pen. Hold on. Hold on.
let me see how I can do this now. Where's my papers? Okay, it's over here. Got your paper?
Oh Lord, I ready.
You ready?
Okay. Yeah.
I am all ready. I am all okay. What is all of that? Okay, hold on 1 second. I'm going to try. Okay, so remember I told you all that I'm gonna put on the exam a pre-incorporation question.
Mm-hmm.
Okay, so I'll tell you now, it's going maybe the same question that I actually gave you on midterm. So what I want you to do is for your respective legislation, read the section again. Because you didn't answer the question properly. So let me go to TCI legislation and let me just show you what I mean. When you read the scenario question, it tells you what someone did, and then it tells you what if. So if you recall the legislation itself, it's not difficult for you to be able to answer the question. Don't answer the question based on emotions. Answer the question based upon what the law states the promoter can do. And then what can the company do in order to correct what he has done? So under TCI, hold on, what's the section for pre-incorporation?
I think it's 141
I'm looking right now.
incorporation.
You got it.
141. Yeah.
The 141. And what does 141 state?
Yeah, a person who enters into a written contract in the name or on behalf of a company before the company is incorporated is personally bound by the contract and is entitled to the benefits of the contract, except where the contract specifically provides otherwise or subject to any provisions of the contract to the contrary. The company adopts the contract under subsection 2.
Okay, so stop right there. So if the scenario says that he went about his business doing things, right? And then the question asks you, is he liable? If all it says is what he did, then of course he is liable. But then it normally asks you, what if? And the what if stems to these same 2 provisions under subsection 1. He can go ahead and he can do it prior to. If the contract says that he is not liable, then he's not liable. Or if the contract says that the company is going to adopt this arrangement and become liable. And then, right, and then it says in subsection 2, the company may, by an action or conduct signifying the intention to be bound by a written contract entered into in its name or on its behalf before it's incorporated, adopt the contract. So the company itself can adopt the contract. But if you are a promoter, you would not wish to enter into a contract without having the contract provide the provision that the company is going to adopt it at a future date. So there's no argument as to whether you're personally liable or not. So they say adopt the contract within such period as may be specified in the contract. So in the contract that the promoter has, he can have a provision within that contract stating that the company will adopt this arrangement by this particular date. Or if no period is specified within a reasonable time, so he could say in a reasonable period after the company's incorporation. And a reasonable period could be 30, 60, 90 days based upon the process for approval for the company to begin its operation or have its first meeting. So you can't say within a reasonable period and it takes 2 years. That's too long. It doesn't take that long to incorporate a company. Then subsection 3 says, when a company adopts a contract under subsection 2, so you see this is the next step. The first step is the promoter going out there, carrying out an action on behalf of a company that is not incorporated. He is personally liable. However, in the contract itself, it can have a provision where it says that the company, once incorporated, then takes on that liability. That's what subsection 2 is all about. Then 3 says, when the company adopts it under subsection 2, the company is bound and they're entitled to the benefits. So once they have done 2 and they have adopted it, the first part was the contract contains the provision that they will adopt it. 2 says, then they state the period upon which they will adopt it. And then 3 says they are bound. And because they are bound, they are entitled to it, to the benefits. As if they had been incorporated when the contract was entered into. And then it says, subject to any provisions of the contract to the contrary, the person who acted in the name of on behalf of the company ceases to be bound by or entitled to the benefits of the contract. So remember, even though without those provisions in the contract, he is personally bound. He tries to reduce his liability and exposure by having that provision put in the contract to say that the company is going to be liable. But this still doesn't leave him off the hook. Because what happens if the company is not incorporated within a reasonable time?
True.
You see what I mean? Because he's then still exposes himself to liability.
Yeah.
So that's what your section says. Now, in the Bahamas Companies Act, what does it state?
Section 22 says, except as provided in this section, a person who enters into a written contract in the name of or on behalf of a company before it is incorporated is personally bound by the contract and is entitled to the benefits of the contract.
Okay, so it's the same as TCI, correct?
Mm-hmm.
Okay, go ahead.
And it says, section 2, subsection 2 says, within a reasonable time after the company is incorporated, it may by any action or conduct signifying its intention to be bound thereby adopt a written contract entered into in its name or on behalf or on its behalf before it was incorporated.
Same as TCI, correct?
Mhm.
It's the same as TCI. That's the same provision.
So if he enters into the contract, before it's incorporated, he gets the same liability, same benefits.
No, subsection 2 is saying that
Entitled.
he enters into a contract as a promoter but within the contract, he makes a provision. In the contract, he says that the company, within a reasonable time, will be incorporated.
But then he would be liable, right?
He's
I
still,
mean,
he's more or less, he will become liable if the company is not incorporated within reason,
it was good time.
gonna go to the court with.
Yeah.
So he exposes himself, but
Mhm.
he's trying to protect himself by putting within the contract that within a reasonable time, the company will be incorporated. So he's moving the liability from himself to the company once it's incorporated.
Yeah.
So go to subsection 3.
Okay. Then a company adopts a contract under subsection 2. The company is bound by the contract and is entitled to the benefits thereof as if the company had been in existence at the date of the contract and been a party to it. A person who is purported to act in the name of the company or on its behalf ceases, except as provided in subsection 4, to be bound by or entitled to the benefits of the company. So,
Right.
question,
So subsection 3 just gives you the effect of subsection 2. That's all it's doing. So it tells you that, 2 tells you that the promoter can, within the contract, put a provision that within a reasonable time, the company will be incorporated and they are liable for this contract. And then it says here that once the company adopts that contract within that reasonable time, the company is bound, they can benefit from it, and the promoter is no longer liable. Now go to subsection 4, because it says person who purported to act in the name of the company on its behalf, except as provided in the subsection 4. So read the exception that's in subsection 4.
okay, except as provided in subsection 5, whether or not a written contract made before the incorporation of a company is adopted by the company, a party to the contract may apply to the court for an order under which obligations under the contract may be fixed or being joint and several for apportioning liability between the company and a person who purported to act in the name of the company or on its behalf, and the court may make any order it thinks fit.
Okay, so what is that? What is subsection 4 telling you?
It's saying that whether or not the contract was written before the incorporation and the company adopts it, the person becomes a party to adopts the whether the contract was written before the incorporation date of the company, right? And the company adopts the contract. A party to the contract may apply to the court under the obligation, the contract may be fixed. They might add both of them to both the company and the person who made who went into agreement with the contract.
Okay, so subsection 4 is saying that you have a written contract. You have the provision in there about having in a reasonable time for the company to be incorporated. And remember what I said, the promoter still exposes himself to a liability. Even though that provision is put in there, his liability is not extinguished until the company passes and ratifies that contract. So subsection 4 says, whether or not that contract is written or not, before the incorporation of the company is adopted by the company. Before that is actually adopted, that contract. A party to the contract can apply to the court. And they could apply as an individual or they could apply jointly and ask the court to apportion the liability between the company and the person. And then the court makes a decision.
So what, so the court makes a decision to remove the promoter or,
No. Liability, apportion liability. So let's just say it was the company, the promoter, and the pre-incorporated company in the contract.
Mhm.
Subsection 4 says that even though you have that contract, the company you were going to do business with, the promoter was going to do business with, can take this matter to court.
Okay, because you didn't live up to your end of the bargain.
That may be the reason why. The act doesn't speak to the rationale for going to the court. All it says is that any party to the contract can go to the court and have the liability apportioned. The only way that doesn't happen is if you follow subsection 5. And subsection 5 says it has to be expressly written in the contract that the promoter who acted for the company before it is incorporated is not in any event bound by the contract, or he is not entitled to any benefits. The contract must explicitly state that. Otherwise, if he just leaves it with just a reasonable notice that the company will ratify the contract once incorporated, he exposes himself to subsection 4, which means he can be sued. Understand?
I think so.
Say it then. Tell me what you think it says, the whole thing.
Okay. Let me see. If I want to start ABC Company Limited, right? And
Mhm,
this company is to say promote artists, right? And
mhm.
I'm the promoter and I enter into a recording. I guess I found like a recording studio and I said I want them to promote XY, right? So and I said that my company is supposed to be formed within, I guess, a week later, right? And the benefit is that if you sign them and they make their first album goes, I guess, reach the top, we split this money 50-50, right? Now, for some reason, I didn't get the monies to form the company, and the company didn't get formed within that 1 week. So now the recording studio could come after me because I didn't live up to my end of the bargain and form this company, but I still want 50% of the proceeds. Is it something like that?
A promoter is normally someone who's going out to enter into contracts on your behalf before the company is incorporated. So whatever he does, he has to be doing it in the name of the company that is not incorporated.
Yeah, so that's why
So
limited.
who's the promoter in your scenario?
The promoter would be
It has to be someone who's acting on behalf of the company.
it'll be an agent, because you have the agents is the ones that I guess locate these people and find people to, I guess, record and do all these other things.
Okay, so the agent is the promoter.
Yeah.
So the agent is going out there and entering into a contract on
Mhm.
behalf of a company that is not incorporated, correct?
Exactly, yes.
Okay, so go ahead now. That's subsection 1. What happens next? How does he reduce his exposure to liability?
Now, to reduce the exposure to liability, I would have to put it in writing that, if the company is not formed within the Pacific time, then I am not whole liable and I won't be whole liable.
In reverse, you have to put it in reverse. You have to confirm to the person you're making the arrangement with that the company will be incorporated by X period of time.
mhm,
The effect of that in that contract means that when the company is incorporated within that time period as stipulated in the contract, the company then adopts the contract and it has all the benefits of the contract. But subsection 4 says that even though you have that provision in that contract saying that within a reasonable time, you will incorporate the company and the company will adopt this agreement, it says that any party to the contract, because remember, only parties to the contract can actually bring an action. Any parties to that contract can go to the court and sue. So it'll sue not just the promoter, but would also sue other persons who are a party to the arrangement. So it won't be the company itself because the company doesn't exist.
no,
So it may be, they may actually sue individuals who they know who purporting to be shareholders in that company. But subsection 5 says that within that contract, even though you put in that provision that says within a reasonable time, the company will be incorporated and ratify this contract. It says, if it says that the promoter is not to be bound in any event and is not entitled to the benefits of this contract, then there's no liability on him. Yes, to specifically state that. So go over it again and make sure put the steps in your head, because TCI one is a little bit different from the Bahamas' legislation, the way it's written.
okay.
So I'm gonna put that as your bonus question. That sounds good?
Donella,
Yeah, child.
One question. Now, I'm not sure if I'm gonna put these together or put them separately, but I'm gonna put a question on company compliance. I'm either gonna take it from the viewpoint of the FCSP as the company, the registered agent, and what it's required to maintain. As a company itself, or I may just take it from the administration of companies. What should the FCSP maintain for each of the companies that it manages and administers? I may do it as a A and B and maybe just say list 4 of each. So that's one question. Company compliance. Let me see. Then I am going to give you a question on. Let me see if I could. So I haven't typed it out yet, but I started writing down I won't deviate from what I tell you, so don't panic. I'm gonna give you a question on striking off and restoration to the register. So that's on corporate insolvency. Striking off and restoration. And I have a liquidation question. I may change it. Let me see. No, I'm gonna keep this one. A liquidation question. It has 3 parts. One on the types of liquidation, the differences between them. The next one is about the order that a liquidator distributes his assets. Let's look at that. So in TCI, what's the order for liquidating your assets? Anybody knows? And you can look up the Bahamas at the same time. The order for liquidating assets. I don't remember. I think I should take that one out, okay?
Okay.
I'll take that one out because you have to go to the insolvency. That could take too long. I'll take that one out. And then the next question under that same one, the next one, the part will now be B. I want you to distinguish between fraudulent trading and wrongful trading. There's a difference.
Fraudulent.
Fraudulent trading versus wrongful trading. There's a difference between the two. Okay, so I'll take this one here out because you need, aren't you so lucky?
Mhm.
My question I wrote, you'll need insolvency act, so I can't do that one either. So liquidation, I'll give you that one. Yeah, I won't do with that. Then I have a question here on the duties of directors. So the duties of directors, I want you to look at the case of Cook versus Deeks.
Cook versus who?
Deeks, D-E-E-K-S. So let me see if I can tell you what the question is about in my. Let me see. Okay, so and I'm going to give you a scenario in where there are directors who are also shareholders. One of them is behaving rather odd, doing things he shouldn't do. And he's going to be making some purchases. And the question is going to ask you, what are the duties of this director? And whether he's breached his duties as a director. So you should know the director's duty. And then whether or not the company can ratify his breaches to make his actions valid. And then one of directors is going to challenge the board decision and you have to comment on that. So on the online, you should see the case of Cook versus Deeks. If you have any questions or anything, you could always shoot me an email. So how many questions is that so far? 1, that's 2, that's 3.
Liquidation has, there's types and differences. Types and differences of, liquidations, right?
Yeah. That's 1, and then wrongful and fraudulent trading.
Mm-hmm. And then duties of directors, and then you said, look up the case of Cooks and Deeks.
Cooks and Deeks. And then you have a question on striking off.
Yeah, striking off and restoration.
Yeah. So I think I should put them separately because they're gonna take up a lot of time. So that's 1, 2, 3, 4. That's 5, eh?
Sure.
2,
And if you
3.
do striking off and restoration, that's 5.
Separately, yeah, that's 5. And then pre-incorporation is your bonus.
Okay, so striking off and restoration is 1 question each.
Yeah, unless I change it and make it into 1, but let's see this one. Let's see.
1, 2, 3.
I know everybody is busy, so I try not to. I could give you all a question on a company and its contracts. Similar like where you have a person who acts in a capacity, let's say chairman or managing director, and he makes his own decisions, and the articles state what he can do, and he goes and he does things that he shouldn't be doing. I should give you that. So what I may do, that's 1, that's 2, that's 3. So 1, 2, 3. Yeah, I'll give you this one. Company versus contracts.
Company versus contract.
Yeah, the two cases you can look at. Freeman and Lockyer.
Who's
Freeman,
that Freeman?
Freeman,
Mhm.
and Lockyer, Lockyer, versus Buckhurst.
Versus,
Buckhurst.
Mm.
Bukhurst. And the second case is Healy, Hely, hyphen Hutchison versus Brayhead, Brayhead Limited. Those two cases.
Company and its contract.
Yeah. 1, 2, that's 3. Put the two of those together. 1, 2, 3, 4, 5. Yeah, so that should be okay. Company and its contracts. I'll do striking off and restoration together instead of doing it separately. A question on liquidation, directors, and then company compliance.
So distinguish between fraudulent trading and wrongful trading, that is under,
Question under liquidation.
okay,
Yeah, along with types of liquidation.
okay. And duty of directors in the scenario where the directors are also shareholders, that's two-part questioning, that's the same.
It actually has. Yes, one scenario, and it has 2 or 3 questions underneath it. And the case is Cook versus Dukes.
so you'll give us the scenario and then we have to answer the questions.
Mm-hmm.
Okay.
And then the company compliance.
Yeah, that's just me asking you. That's not a scenario.
Okay,
Be a simple question asking you, what are the documents that a corporate service provider should maintain as a registered agent, registered office?
Well, that's the company compliance.
That's the company compliance. And then I could put list 4 items, and then I could say B. What is required for a company to provide corporate service? List 4 statutory or 4 regulatory requirements. 1 is it must have a license. 2, you could go from there. It must have an MLRO. 3, like that. So that's a giveaway question. To me, your most difficult questions will be the one on directors and the one on company contracts. And then striking off and restoration, I'm going to give you a question on that. Sounds good? And of course, the bonus is the pre-incorporation. And if you can't find a summary of the cases, I can send it to you.
Okay.
So that's just 3 cases. I don't think that doesn't sound too difficult, right?
Well, I'll start reading.
Stop reading. Stop reading. Start reading. I don't think it will be, but read and make sure you read the cases. And if you have any question on the cases in terms of if you're trying to decide like what principle in the case you need to know in order to answer the exam question, then you can shoot me an email. But you really just need the summary. And I could direct you. Okay?
Yes, ma'am.
Right. And remember, these answers are not long as a hill. And don't forget your capstone. Those are long.
What is it again?
The capstone is due on the same day as the exam.
What is the capstone again?
What is it again?
Oh, Lord, the capstone was 1. Part A was 40 points. The company law fiduciary duties of a company directors were frequently criticized for being too far complicated and difficult to understand, as well as being rooted in the past rather than fit for purpose in modern commercial environment. And you have to discuss that. And then part B, you have 5 answer 3.
Did we get a breakdown of the capstone, like how you're telling us now?
Yes, I sent it.
I
What?
didn't see
I
one.
didn't get that.
I didn't get that.
No,
No.
me neither.
I'm gonna send it again. No, I was wondering how come nobody was asking me any questions.
No, I didn't get a breakdown.
I never even got the email.
Me neither.
Oh, Lord. Okay. I'm gonna send it again to the office so they can send it to you. Thank God it's due on the day of the exam. I probably have to give you all 2 weeks extension now, right?
Please.
Yeah.
Yeah, I have to. Let me change. I'll change the date on it right now. So there's no confusion.
Okay, so it'd be a 2-week extension on the capstone, but the final will still be on the same day.
Yeah, final will still be on the same day.
Okay, great.
Okay, so let me put it to September the 22nd. Okay, I put it to the 22nd. But the final will be on the same, on that date. On the date. I think on the date on your sheet
Okay,
is
so the final is staying at the 6th.
no, the 6th is a Wednesday.
Oh, when is
Hey, what?
It should be 9th.
I know, yeah, 2 minutes. Just give me 2 minutes.
That should be the 9th.
the 9th?
Yes.
So the finals is on the 6th?
No. It should be on the 9th.
The final is on the 9th.
Oh, let me see.
Final is on the 9th.
Oh, because it said the thing says final is on Saturday the 6th. That's the 9th and instead of 6th.
Supposed to be the 9th.
Okay.
And then you will hand in your capstone 2 weeks after that.
Okay.
That'll give you sufficient time. So you have practically a whole month. No excuses. More than a month.
Hey, Sean.
Okay, so any questions you can let me know with regard to the cases.
I am class.
Probably send you a copy of the summary.
What is for? Thank you, Mom.
Okay.
You heard anything else?
So if there's no more questions, hold on,
Check the site. I'll say the password so you can get in too.
9,
Say the password so you can get in.
10, okay. All right. So I look for your emails in case you have any questions. And like I say, if you look for the cases, let me know. And then I could always send you a summary,
Okay.
all right? So don't wait until the last minute. And then you start to panic. All right? Okay. So it was nice meeting all of you.
It was a pleasure. I
Yeah.
enjoyed being with you guys.
I enjoy. So Donnell, I'll be emailing you too.
Okay, no problem. Are you on social media or anything?
I'm on WhatsApp, I'm on Facebook, but I don't hardly, I'm on WhatsApp more than Facebook.
Okay,
I might not answer right away, but on WhatsApp, but I'll answer.
okay. I can give you my number,
Okay.
244. It's
Hold on.
619. Sorry, 619.
244
0856.
0856. What's the prefix?
The area code is 649.
649. Okay, so that's 244 0856.
Yeah.
Okay.
Are we creating a group chat?
We
Yeah,
can,
we should.
I
Yeah,
think
can
we
do that.
should,
Yeah, we should do that.
we
Yeah.
should have done that from the beginning.
I know,
I
right?
thought we're creating a trip to go to TCI.
Man, that might be next.
That's what I thought you all were creating.
Nice.
All right.
So who's gonna create let me send my number.
Tamaya, you want to do it? Let me type my number in
Let
there.
me do it now.
Okay.
It's always best to do things now.
Yeah, before you forget.
Okay, I have to save the numbers. Miss Walken, you live in Nassau? Oh, no, sorry.
No, I'm in Turks.
And we had a couple students from Nassau, Miss.
Yeah, with it.
I don't know. Don't worry. You'll sit them for the exam.
Okay.
Oh, wow.
They probably just listen to the recording or whatever.
But
Probably.
all the recordings don't be online.
I know.
I prefer to come in and then have discussions, you get a better understanding.
Yeah.
You'll see. Yeah, it was about how many more people? 5 more?
I think it was like 8 of us. I mean,
Yeah,
One
it was
time.
quite a bit.
Okay, you want to be added into the group too, Miss,
You could always add me in when you need me. You have my number, right?
yes, ma'am.
Okay, yeah, you could put it there.
Jeremiah, so apparently it said I have to invite you to the group. Um,
Oh, Elisa's number. Let me give you Elisa's number. See.
okay, hold on. It's telling me, that Jeremiah's number. J-A. Yeah. Okay. 619-345. Oh, I had it wrong. 6983. Okay, post it in the group and I'm gonna make you an administrator so you could add, okay? Okay, Donello. I'm having issues.
Trying to add me administrative.
I don't know, I do an administrator. I'm trying to change, I added her, but it's not saying that she's on
Okay.
6-5.
If I can add her, I can see if I can add her.
Yeah, because you're an administrator.
Okay. Okay, she's there.
Okay,
She's there. One, two. Oh, I have to add Jamadia to it.
yeah, because apparently for some reason it's telling me that she's not on WhatsApp.
Okay. Number is. The numbers again.
It's 345-6983.
3, 4, 5, 6, 9, 8, 2, 3, 4, 5, 6, 9, 8.
Okay, I just added you, Mrs. Archer.
Okay.
So I can add it out. Couldn't add Jamadia. You can invite them privately, join this group, really?
Yeah, that's what I said. It's like she's not on WhatsApp. Like she doesn't have it.
Yeah, let me send her an invitation. That don't make no sense. I sent her an invitation. Let me see if she can. Jamari, you seen the invitation from me? Jamaria?
Yes, yes, I see it. Sorry.
Okay, okay, okay. So we all set now?
I think so.
Go and see. Yeah, I see it. It says forever blessed.
Yeah.
Mhm.
Okay. All right. I answered.
Oh, I was trying to.
Okay.
Hmm.
So the other Bahamian students, I guess, still miss out. So,
Mm-hmm. Well, they'll be the ones right there looking around, looking around. Let's see who sends an email.
Mhm.
Let's see. Okay.
oh. Okay. I have to go pick up my daughter now.
All right. That's fine. Thank you very much for your
Thank you,
effort.
too. Yes, ma'am. I guess this will be our chat, so let me go into Turks, Miss Archer. We have 2 contacts.
We have contacts, yes.
Yes.
We call and say we're here.
Hey, pick us up from the airport.
We're here. I see.
So we will keep in contact with our chat.
Yeah, and
Yeah.
I'll just follow, see what you all are saying.
Okay,
Okay, not a problem.
okay.
All right. Enjoy the rest of your weekend.
You
You
too.
too.
All right, and have a fun time studying.
Yes, ma'am.
Have a good vacation first.
But vacation first, yes, and then study.
Yeah.
All right.
All
Okay.
right.
Bye.
Later.
All right,
Bye.
okay.